Tonight, the relationship between Karen Read and John O'Keefe takes center stage.
That night they were affectionate?
Yes.
Laughing?
Yes.
Happy?
But prosecutors say there was trouble brewing in the hours leading up to O'Keefe's death.
If you tell me you're interested in someone else, you will never hear from me again.
Plus, the strategies of both the defense and prosecution are becoming clearer.
Sir, I'm asking you about your testimony.
So let him answer the question.
But will either strategy sway the jury? Our legal experts break it all down. Canton Confidential, the Karen Read murder trial, starts now.
Court unexpectedly ended early today, but we still saw some impactful testimony from a number of prosecution witnesses. Good evening. I'm Glenn Jones. JC is off tonight. 5 witnesses in total took the stand today. That includes a couple witnesses who testified about the final hours of the relationship between Karen Read and John O'Keefe. Our Melody Mendez is covering it all from Norfolk Superior Court in Dedham. She joins us live now. Mel, jurors got a feel for the couple's relationship with each other.
Glenn, exactly right. They did just that through 2 vantage points here. So first was John's friend who took the stand. He spent quite a bit of time with John and Karen. They got to see the relationship through his eyes. And then secondly, and perhaps most importantly, a trooper on the stand read the text messages sent back and forth between Karen Read and John O'Keefe in the day leading up to his death.
That January of 2022, you observed their relationship in your presence to be normal, caring, and affectionate, right?
Yes.
Michael Camerano, a friend of John's who was drinking with the couple the night of January 28th, giving an inside look at Karen and John as a couple.
They argued and bickered.
You had previously testified that you wouldn't even call it arguing, you just call it banter, right?
Yes, I mean, he would, he would get upset or like over if she bought expensive things for the kids.
Right. Or he'd complain if, Karen was taking his niece and other girls to get their nails done. Like extravagances like that?
Correct.
That source of contention over treating the kids becoming clear in the text messages later read aloud in court by Trooper Nicholas Guarino, starting with the aftermath of an argument.
From Karen Read to John O'Keefe, you have really hurt me this time. From John O'Keefe to the defendant, I'm sorry, this has been an issue with me for 8 years. It physically hurts me to see everyone else in their life do things for them, and I'm forced to always be the bad guy.
In a number of texts, O'Keefe grappling with his new role as a parent, Read as well.
Most of the time I try to do what is healthy/smart for them. More importantly, I try to support you in what you need. You just lashed out at me and said terrible things. I don't know how you've gotten to this point with me when I'm just trying my hardest.
The couple go back and forth repeatedly, both sharing their struggles. Karen writes,
physically, I am falling apart and trying to get answers and help.
John replies,
I know. I'm sorry for lashing out. I'm just hurting and struggle daily with them. Always feel like I'm failing at this parenting thing. I wasn't built for this.
The arguing, vacillating between affection and anger, would go on for hours. O'Keefe rejecting Read's calls several times, the couple speaking for a few minutes here and there, and Read repeatedly asking O'Keefe to meet her for drinks.
John O'Keefe to the defendant, sick of always arguing and fighting. It's been weekly for several months now. So yeah, I'm not as quick to jump back into being lovey-dovey as you apparently.
They're back and forth interspersed with discussion of plumbing issues and parenting duties.
From the defendant to John O'Keefe, I'm having issues with my hot water, so had to text someone to take a look. John O'Keefe to the defendant, check the hot water heater and see if it's leaking.
Finally, just after 7 p.m., O'Keefe says he and Camerano are headed out for drinks.
Just turn it back to where it was and get over here. From the defendant to John O'Keefe, I'll head up there in a few min. Let me know if you leave.
They would eventually settle on plans to meet later that night. Now, the jury is back tomorrow, Glenn, for half a day here in court.
Do we know what's happening tomorrow, Mel?
We do, Glenn. In fact, so we know there's one witness set to take the stand, but perhaps more importantly, the jury is scheduled to take a field trip of sorts. It's called a view. Essentially, they will be taken by bus to the scene where John O'Keefe's body was found there at 34 Fairview in Canton. We'll be there to cover it all. Live here in Dedham, Melody Mendez, NBC 10 Boston.
It'll be an important moment in this trial. Melody, thank you. Let's welcome in retired Judge Jack Liu, as well as defense attorney Morgietta Derichiere. We're going to focus on courtroom strategy with the two of you tonight. So let's begin with the prosecution. Here's a clip I'd like you both to listen to so we can talk about on the other side.
And his mother leans over the kitchen island and says to me, I think it looks like he got hit by a car. It looks like he got hit by a car.
That was a clip of Karen Reed talking about John O'Keefe's mother from an investigation discovery docuseries. Prosecutor Hank Brennan plays clip after clip for the jury between witnesses. He's also had excerpts from Reed's interviews with 2020, Dateline, and Boston Magazine, using the defendant's own words to weave a story. These clips have led to this question from a viewer. They write, how is the prosecution able to introduce the clips of Karen's various interviews between witnesses? I thought that evidence could only be introduced through a witness with context. I have to admit, I had sort of that same question while I was watching the trial. So, Judge Liu, let's start with you. I guess I assumed there'd be a rule that prevented the prosecution from using these video clips in this way. Is that the case? And have you seen it before as you've presided over trials?
I don't think I've seen it personally done quite as well. Mr. Brennan is surprising us maybe in showing us that he's quite the artist. And this is a rare instance of a really highly skilled lawyer using electronic media in the courtroom.
So you would say it's effective?
Yes, but you know, with the stage we're at, we're in the prosecution's case, we're going to be in the prosecution's case forever. It's natural that it would look good for the prosecution. So we don't want to give that too much weight.
Okay. Murgieta, that clip we just played, the defense did object to it being introduced. Ultimately, the judge dismissed that argument. I think what the defense was saying is that the clip impeached their own witness, Peggy O'Keefe. But when you listen to it, is there anything problematic with a defense attorney's ear that you heard or saw?
So I think we have to take a step back and remember that the defense stipulated to this information coming in, to this evidence coming in, and partly because in the rule of hearsay, there's a rule about statements of a party opponent, meaning the other side coming in. So Karen Reed is a defendant, so her own statements, because she's a party to the case, naturally would come in.
Sure.
Now, in a lot of cases, we don't get to hear the defendant because, remember, they don't have the burden of proving anything. So it is very strategic that the prosecution is using this as her way of getting her statements in without her actually sitting and testifying. It is a little cringy as a defense attorney to hear your own client's statement being played in front of a jury, but I'm sure they had that discussion prior to her doing any of these interviews. And I think the reality is that she wanted her story told, and it's easier to control that narrative when you're doing the interviews as opposed to someone telling the story without you being present.
But it comes with a risk.
It comes with many risks.
The prosecution has also developed a strategy with State Trooper Nicholas Guarino. He was called back to the stand a second time, but he's yet to be cross-examined, and Hank Brennan plans to call him a third time. So, Judge Liu, help us understand this strategy of bringing a witness up, having them leave the stand, coming back again, and now we learn he could be coming back a third time.
Well, he's doing different things, and some of the things, as a former judge, I will say they don't need to be doing, like reading all these text messages. They're not required to read them. So
you think it's excessive?
Well, if I were the judge, I'd be privately saying, "Hey, do we have to read every single one of these?" You know, in a sidebar conference or something. But I wouldn't call it excessive just yet. But you don't have to do all this. They could literally just put the pictures of them into evidence.
Okay.
And read 102.
Let's talk about the strategy of the defense as well. They've been hammering the memory of the first prosecution witnesses. Here's how David Yannetti cross-examined first responder Daniel Whitley.
Nowhere in your answer in April of 2022, before the grand jury, did you testify under oath that Ms. Reed told you that John had actually been in the snow for many hours, correct?
Not in 2022 of April.
So Jackson and Yannetti, Murgieta, have been really concerned with impeaching witnesses based on what they've said previously. What's the objective of doing so?
So the goal of impeachment is really to tackle somebody's credibility. But I think you have to do it strategically. If you continue to use impeachment tactics and you're not going after the big impeachment tactics, then you sometimes come off as a bully, and it just looks like you're attacking a witness on the stand. And I get strategically they want to nitpick some of these different words and it's different semantics. Strategically, I may have not gone that route. I would have waited for the bigger ones where you're really trying to show them that they lied on the stand. And now it kind of looks like a tit for tat, back and forth kind of thing. It doesn't seem as effective. And as the judge said, you're belaboring a point that the jury gets. Remember, most of the jury already knows the facts of this case, and they still have decided to sit on this case. So belaboring some of these semantics and words, I don't think is as effective as I think it's coming across.
Yeah, no, we've seen at least 3 very strong crosses on that same point. Let's go to another viewer question, because this one is so interesting. It pertains to the noticeable change in the retrial. A viewer writes, why is Karen Read allowed to go up to the sidebar with the attorneys? I don't recall her doing this in the first trial. I've always thought it was only for the lawyers. So Judge Liu, how common is this, a defendant going up to sidebar with her lawyers? Is it something that you encountered when you were on the bench?
The defendant, Ms. Reed, totally has the right to do it and had the right during the first trial. I've been sitting here trying to search my memory. I'm having a hard time remembering a case in 21 years where I had a defendant who was coming up the sidebar for everything, where there were lawyers. Sometimes you do get defendants who represent themselves who are not lawyers, but but it could have happened. It could have happened, but that may be the only time I've actually seen it. It's not rare for jury selection.
Right, to have input in that process.
Yeah, so the defendant goes with the lawyers, but it is really rare for the whole trial.
Morgietta, you ever had a client who wanted to do that?
I've had very complex cases, and I think the reality is that this is an ongoing case. It's a day-to-day case, and Karen Read, as you can tell, is very involved in the process of this case. So I don't blame her or the defense team for wanting her to be 100% involved. I've had clients come up to sidebar. You're hearing the real live results from the judge and rulings from the judge. And I think she said in one of these clips, she's been doing her own research and she's been doing her own legal analysis. So I'm sure she understands what's happening. It is rare, but she's allowed to do it technically.
All right. And she is definitely exercising that right.
Yes.
Judge Liu, thank you very much for joining us. I hope to have you back again. Your
Great pleasure. Thank you for having me.
So useful. Morgietta, please stick around. And if you have any questions about this case, send them our way. We've got the email address up on our screen, canton.confidential@nbcuni.com. We'll answer as many questions as we can. Coming up next, we delve into a very contentious issue in this case, the ARCCA experts. They'll be back Monday for questioning after the judge found potential discovery violations by the defense. Why this issue continues to cause grave concerns. You're watching Canton Confidential, the Karen Read murder trial.
Don't miss any of the Karen Read murder trial. Get the full recap of what happened in court, expert analysis, and what we could see next. This is coverage you won't see anywhere else. Canton Confidential, weeknights at 7 on NBC 10 Boston.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, now holding in Dedham within and for the County of Norfolk.
Like many of the key players, Judge Beverly Cannoni is back for Karen Read's retrial. NBC 10 courtroom insider Sue O'Connor joins us now. And Sue, we've been talking about the differences between these two trials. Judge Beverly Cannoni is a consistent factor, but has she been acting or presiding differently based on this second trial?
Well, I will tell you she has not had to tell anybody to speak up, which was a constant in the first trial. She also hasn't really had to butt in, I'm saying that respectfully, in many ways like she did so far at this point in the first trial. Having sat and watched her for some 40 days last year, I do feel like I know her.
Sure.
And I do feel a little bit like there is a slight tinge of exasperation that she's having with all the parties. I know that if you have one side or another, you pick it out. But there is this there was a first responder up who said, I don't know, I need to look at my report. And then was asked, do you have your report? And he said no. And I swear she looked at Special Prosecutor Brennan and just was like, oh, he doesn't have his report. Like, can we move this along? So, and she's also a little bit more a mediator, I think, in a way, that when there was a struggle today, as you were talking about really hammering, what you said and what you meant, she tried to mediate a little bit, I think, between Yannetti and the witness, like, let him finish the question, answer the question, let's just try and keep this civil and move along. So again, it's season 2, and I think she knows what she needs to do to move this along.
All right. Well, speaking of Judge Cannoni, she's scheduled a voir dire this Monday. Accident reconstruction experts from ARCCA will be brought in for more questioning due to discovery violations by the defense. Here's what she had to say this week on that subject.
So I am indifferent to this voir dire. All right. I'm trying to help you out by having the witnesses here because I found a violation of your reciprocal discovery. So I don't know how long this is going to go. I would assume I'm giving you the opportunity to put them on and the Commonwealth an opportunity to cross-examine them.
It's important to underscore this for our viewers because ARCCA are accident reconstructionists. In this trial, a vehicle is the alleged murder weapon. And we consistently have these issues where there's concerns about whether the defense is handing over things about ARCCA that they're supposed to hand over. What could be the implications of what happens on Monday?
So I think we have to remember that the factual details that ARCCA have are the facts. That information should come in. When you're talking about discovery violations, you're talking about sanctions, meaning should one side be punished because they didn't, quote unquote, follow the rules. So this voir dire is really to pull out what information are they going to be testifying to? And is that information sanctionable, meaning should it not come in? Now, the issue is that information prejudiced to one side versus the other? Because they're still facts. It's still a report. There's still an agency that actually conducted this work. So what Judge Cannoni is really going to evaluate is the prejudice to letting this information in versus not letting it in.
And what you're talking about could extend to the communications between ARCCA and the defense as well.
Absolutely. And both sides have a responsibility, right? The defense is trying to create this reasonable doubt, and the prosecution is trying to create this narrative against Karen Reed, right? But is that information, one, relevant, and is it going to prejudice the other side, right? The reasonable doubt, you need that information in there because there's a lot going on with this investigation. But does the information that ARCCA is going to point to from the prosecution standpoint going to point to the elements that she's being charged with? That's all going to come out on Monday.
Okay. Earlier, we talked about video clips being played in court. That includes one from the Investigation Discovery docuseries on this case. That brings us to another viewer question. One viewer asked, can someone please tell me how a documentary film is allowed to be made when a murder case has not even started? And how does it not influence many of the people involved with the case? By the way, we previously reported that Jackson and Reed went out looking for a documentary partner, so they initiated this. Sue, you were interviewed for the docuseries on ID. What's your understanding of how all this came to be?
Well, first of all, it's their First Amendment right in order to be in the docuseries or do anything they want. It's about whether or not they can make money from it if she's found guilty. That's the issue that's only attached to this. So you can do anything you want prior to your trial, during your trial, unless the judge gives you a gag order. My understanding is that for the docuseries, an intermediary approached the producer from Alan Jackson, and they had her have complete access from before the trial even started, is my understanding. So I don't know that they thought they would have a second trial.
Right. You would presume not, right?
They might regret having done it, but at the same time, they're well within their rights to do it, and this is America. You have your right to free speech.
Yeah, we talked with Judge Liu about the use of those video clips. What's your view of the way that Special Prosecutor Brennan is using them?
So I think part of the objection, and the Prosecutor Brennan will still get the objections if he's not using them in proper context. So we did not see, I'm sure, what the stipulation is. I'm sure the parties stipulated in writing to what is actually going to be played, how long it's going to be played. But you have to use the rule of completion. You cannot cherry pick the pieces that you want to come in. You have to provide the full context. And that's why he got that objection, because it's being played out of context. So the defense, I'm sure, is going to come up on their side and play the full context or continue to make objections if it's not being played right. But what can you do at this point? The information's already out there. The world has already seen it. Karen Read has every right to tell her story, and she has. And as I said earlier, it's better for her to get her story out in her words than for somebody else to tell her story in their words.
And Glenn, I would just say one other thing. You know, I was in that docuseries, and I said that there was a small window of time where evidence could have been planted. I didn't say it was planted. I didn't say there was intention to be planted. I don't know what I said before. I don't know what I said afterwards. And that's the context you need if I was going to be on trial for that statement. The statement alone needs to have the house it lives in for a trial. On a docuseries, I just filled in a blank.
All right, Sue O'Connell, Morgiana Drissier, thank you very much. Remember, you can join us here on Canton Confidential, the Karen Read murder trial, every weeknight at 7. We'll have a full recap of the latest developments from court as well as legal analysis. Plus, episodes will be streaming on Peacock starting this Sunday. And coming up on our next episode, we focus on a key Supreme Court conference. Justices will debate whether to take up Read's double jeopardy appeal. We take a look at the potential next steps for Read's appeal. Plus, a juror from the first trial will join us. He'll offer his unique perspective on tomorrow's jury visit to 34 Fairview Road. This is Canton Confidential, the Karen Read murder trial.